Hi, Kushal. Can you hear me?
Yeah, Utkarsh.
Great.
Uh,
We'll just wait for Vikas sir to join. We are already live.
no problem at all. You can hear me. Everything is clear.
All clear. Your video is clear. Your voice is clear.
Great. Great.
Thank you. Thank you so much.
Hmm? आगे? Hmm.
Hi, Satish. Are we clear on the live streaming? Hi, Mrityunjay. Hi, Mrityunjay. Can you hear me?
Okay, who wants to stream in? एक बड़ा फैन एक बड़ा फैन 1599 यहाँ ब्लॉक में
Hi, Kushal. So we are just waiting for Sir to join and we'll be ready to go.
Sure, no problem.
Yeah, thank you. Thank you.
Oh, विकास सिंह आ रहा है दिखाओ
Good afternoon, Vikas sir.
Good afternoon.
Sir, if you permit, we'll start.
Yeah, of course we can. इसके ऊपर कुछ वेट रखना पड़ेगा और ऊपर बहुत दीजिए बड़ा वाला Just 1 second.
Sure.
इसके ऊपर कुछ वेट दे दीजिए यही दे दो ना ये दे दो हो जाएगा उससे भी हो जाएगा Yeah, hi, we can start. Yeah.
Sure. Hello, everyone. I welcome our speakers and everyone joining us from across the country today. Today, we are joined by senior advocate, Mr. Vikas Gupta. He doesn't need an introduction today.
Vikas Singh, not Vikas Gupta.
Vikas Singh, sir, so sorry. He doesn't need an introduction today. Possibly everyone across the country knows him and his work. Vikas sir, today when I have the privilege to talk to you, I just wanted to convey to you first, it's the verdict like these as passed by Supreme Court in Sushant Singh Rajput's case that reignites confidence of people on the judiciary and the democracy. And second, now this is a feedback which I received from a lot of law students, that it's lawyers and role models like you who assist the courts in passing such judgments of national importance and legal significance that motivates students to pursue law and specifically pursue criminal justice. Thank you so much for all your contributions, sir, and thank you for joining us today. Today's session will be moderated by Kushal Moore. He has been practicing criminal law for over a decade now. He has been a part of some very notable and high-profile cases, including the Sheena Bona case, MCGM road scam of 2015, to name a few. That will be to the objective of today's session. In this case, we have seen a lot of media coverage in different aspects of the case. Today's session is to focus on the legal issues that was dwelled into by the Supreme Court in its judgment dated 19th August 2020. With that, I request Kushal to take the session forward. Over to you, Kushal. Thank you.
Thank you. Thank you, Utkarsh.
This bottle Yeah, hi.
Hi, sir. Pleasure having you here. Firstly, I must congratulate you on the verdict. But to add to that, I'm not sure, is that what you or the family wanted? Or is it somewhere midway a balancing act between that the court has done?
No, we wanted this only. So, when the original FIR was registered, we had thought that we'll go to the Patna police because we felt that probably this matter, if we straightaway ask for CBI, it may not get that kind of attention because CBI is handling so many large number of important matters, and we thought this matter will get lost. But when, the Patna police was obstructed by the Mumbai police and the city SP Patna was quarantined, that is the time we realized that now we will lose time unnecessarily in this fight of jurisdiction. So might as well agree for the CBI investigation. And fortunately for us, the Chief Minister obliged and the central government also obliged. So things started moving very fast. But you're right. I mean, this decision is definitely in sync with what we had wanted it to be.
Right, sir. So congratulate once again. And I think the family must be happy and looking forward to a fair and impartial investigation. So before I delve into the, like Utkarsh mentioned, since a lot of the viewers are law students, they want to understand the legalities. Before I delve into that, sir, briefly, I'd just like to summarize the brief facts leading up to the Supreme Court verdict and discuss all the media reports because I am not privy to the information. So if there's anything, please do correct me, sir. So from what we know, on June 14th, Sushant Singh Rajput allegedly committed suicide at his Bandra residence. And the body was found by the domestic help and it was informed to the police. And the police seemed to find some prescription related to depression and no suicide note at the site. On June 24th, the PM report signed by a team of 5 doctors was received by the Bombay police, indicating that there was no struggle marks and the death was due to asphyxia. July 16th, Riya Chakraborty came forward with screenshots of death, rape threats on social media. At the same time, she also called for a CBI probe by tagging the Union Home Minister, Mr. Amit Shah, on Instagram. Thereafter, on July 29th, the forensic report also indicated that the cloth allegedly used by the hacker to hang himself was strong enough to take his weight. It further revealed ligature marks on his neck, pointing towards suicide rather than homicide. On the same day, Riya Chakraborty also moved the Supreme Court and sought transfer of investigation to the Mumbai police in the petition of which we discussed the judgment. She approached the Supreme Court after the Patna police 4-member SIT arrived in Bombay. Thereafter, sir, on August 6th, CBI registered an FIR under sections 341 and also under 306 amongst the other sections of the IPC. And August 6th, the state of Maharashtra filed an affidavit before the Supreme Court challenging the FIR registered in Bihar. And I believe you filed an affidavit on behalf of Shant's father, alleging that the transfer petition had become infructuous, as the investigation had already been transferred to the CBI. And on August 19th, we have the verdict, which we will now discuss in some detail. Keeping in view, the viewers are mostly students. So the first question, actually, which there has been a lot of hype and which is talked about, is regarding the jurisdiction. And I don't mean the jurisdiction of the Supreme Court. We'll come to that a little bit later. But principally, first, whether the Patna police had jurisdiction to register the crime. And, in that, I have seen your written submissions and also some part of the judgment, wherein you have said where the consequence of the offense flows, even that police station would have jurisdiction. So could you briefly elucidate on that aspect, sir?
Well, the traditional jurisprudence, criminal jurisprudence is that jurisdiction lies where the actual offense occurs, which is 177 of the CRPC.
Absolutely.
But the story doesn't stop there. That is only the general power of general jurisdiction determined by the CRPC. There are exceptions to 177, which is 178 and 179. 178 says that if part of cause of action has arisen in another place, then that place also will have jurisdiction to register. Now, in criminal jurisprudence, as you know, or I don't know, I think all of you should be knowing by now, that there has to be only one FIR. There can't be multiple FIRs.
Absolutely.
The Supreme Court has held that there can be only one FIR.
Yes.
So wherever there are multiple jurisdictions, if there is one FIR, then that FIR will take care of all the jurisdictions.
Yes.
So if supposing a crime is committed in 4 jurisdictions and an FIR registered in any one of them, then all 4 areas will be the subject matter of inquiry, investigation, etc., even arrest by the police of that one place where the FIR is registered. And the next section is 179, which talks of consequence of a crime.
Yes.
So in that, this is the first case where consequence of a abetment to suicide has been considered to be also in Patna. But there were already cases on, criminal misappropriation, where the Supreme Court already had ruled that a place where you suffer the consequence of a misappropriation will also have jurisdiction. Now, there is a subtle distinction between a case which is simply criminal misappropriation or which is also a case of this kind, where there is no criminal, may not be any criminal misappropriation, but some consequence may have ensued. Because if there is a criminal misappropriation, then under 181(4) of the CRPC, the place where the consequence has ensued is further elaborated that that place also will have jurisdiction. Now, 181(4) doesn't talk of these kind of offences like abetment to suicide or maybe even murder.
Yes.
So, for abetment to suicide and murder, we have to fall back upon 179 only. Now, when you look at 179 talks of consequences which ensue of a crime, that place also will have jurisdiction. Now, many a times you will see that there are, these dowry matrimonial matters where a girl, suffers all the harassment at one place
Yes.
and then goes and resides with the parent at another place.
Sure.
And then at that place, the FIR is registered. And the Supreme Court has taken the view in those cases also that that place will have jurisdiction. So,
Recently, some
even
three
in, yes, so even in cases where the consequences ensue is a place which has jurisdiction. So when I decided on behalf of my client, the client came to me at a time when this was around middle of July, so almost 1 month had passed from the death of Sushant, and nothing had progressed in the matter. And they had not made a formal complaint to the Mumbai police because they didn't have faith in the Mumbai police. But they had already made a complaint prior to his death that they fear for Sushant Singh's life from that Sushant Singh is in danger because he's surrounded by people who they fear, may have some he needs protection from. Yes. So that complaint was not taken. No cognizance was taken of that. And when you make a prior complaint with regard to, fearing that person is likely to, be harmed by somebody, and when that person is actually harmed, then really speaking, there is nothing more to be done. Police has to take it in that direction and has to ensure that that there was an apprehension by the family earlier. Mera ek wristband hoga
Yes.
That the family has already said that this is a case where they were fearing threat from these people, and now the person has actually died. So the natural consequence will be that you will start in that direction only.
Absolutely.
Now, what the Mumbai police started doing was, firstly, it did not register an FIR.
Yes.
So if you don't register an FIR, then obviously you can't do an investigation, because in criminal law, investigation starts only after the registration of an FIR.
Absolutely. Sir, before we come to that, sir, I'm sorry. So before we come to that, now, sir, in this, that Patna police has registered the FIR, and you explained very well as to how 179 and 181, if we read both of them together, Patna police did have the jurisdiction to register the FIR. However, sir, once the FIR was registered, was it not incumbent upon them to then transfer that FIR to Bombay police? Because, like you said, the suicide did happen in Bombay, and except for the allegations under 406 for criminal breach of trust.
So you let me proceed in my manner. I'll come to that also. That is what is called a zero FIR.
Yes.
So when we decided that no point of going back to Mumbai police, because if we file a formal complaint with them, the direction in which they are going, they will, because ultimately policing is something which is very professional, and if they don't want to do it professionally, there is no way you can force them to do it professionally. You can't force them to ask a particular question from a witness. You can't force them that the person should be custodially interrogated, etc. So there are so much of discretion with the police which nobody can control. So it is at that point of time that we decided to register the FIR at Patna, and Patna, as I told you earlier, it was 179 and 181 and 178, 3 sections. Because part of the cause of action arose at Patna because father was cut off from the son from Patna, because he wanted to talk to him on telephone, and Ria did not allow him to talk to him. And if that mentoring had continued, or if that channel of communication had remained, probably he would never have gone to depression, whatever she was saying, and his mental health would have been quite all right. So it is not only consequence, but also part of the cause of action. Now, when you talk of part of cause of action, or if you talk of consequence, then there is no concept of transferring the FIR in those cases. Transfer of FIR takes place in a zero FIR. Now, what is a zero FIR? Zero FIR is where the complainant himself or herself states to the police that I fear that this FIR will not be registered at the place where the actual offense took place, and I, for some reason, do not, expect that if they will not register the FIR, or if it is not convenient for me to go there and get the FIR registered for some reason. So then you get it registered. So complainant himself or herself declares that this place does not have jurisdiction, but please register an FIR because it is convenient for me to do so.
Right.
Those are the zero FIRs which are to be transferred. And the classic cases of the Asaram Bapu case,
Yes.
where this girl, whatever Asaram Bapu did to her in Rajasthan, she was a resident of UP and she was passing through Delhi, and in Delhi she decided to get the FIR registered, and the FIR was registered, and that was a zero FIR which was transferred to the Rajasthan police. So where the complainant himself declares that it is a place, this place does not have jurisdiction, but I am registering this FIR only to save time, or it is inconvenient for me to get it registered at the right place, or if they feel that the persons against whom the FIR is to be registered are very powerful and it can't be registered because of them. So like for instance, a girl, something happens to her in Delhi, and by the time she is able to regain, her composure, she's already in Noida. So she can say that, look here, everything happened to me in Delhi, but I could not register for XYZ reason. It was night, it was late or whatever. And I was running away from these people. So I have already come to Noida. Now please register an FIR. It is those FIRs where the complainant herself declares that this place does not have jurisdiction are the ones which will have to be registered only for the sake of registration, so that the FIR gets registered and then transferred to the jurisdiction.
Right.
In all other cases where the complainant feels that there is part of cause of action, or the complainant feels that the consequences ensued, complainant feels, this is important. It's not that the police can exercise a discretion in that. If the complainant feels that part of cause of action has arisen here, or the complainant feels that the consequences ensued here, then that police has not only to register the FIR, but also to start the investigation. Now, you talk of jurisdiction. The jurisdiction issue does not come at the stage of registration of FIR. The jurisdiction issue comes only after post-cognizance, when the matter goes to court. Then the court under the CRPC is to again for the first time take a call whether this matter should be tried here or it should be sent to some other court which will be considered to be more convenient, or which will have the jurisdiction to try the matter. So in every case, and that is clear from a plain reading of 156(2) of the CRPC, where 156(1) says that investigation will be done by the police where the crime has been committed. So in fact, in 156(1) also, if the part of cause of action is there, or if consequences ensue, then also 156(1) is very much applicable. So that is the place where investigation can continue. And further in 156(2) it says that no question of jurisdiction will arise at the stage of investigation. So in any case, whether the jurisdiction lies or not, investigation has to start by the police. Now I'll tell you, this is very salutary, because you see a person, from a small town going and working in a big town and suffering something like this, a consequence like this, whether he's murdered or, he's forced to commit suicide. Do you expect that that father of that person, small boy or young man, to leave the small town and go to the big town and register, get the FIR registered and fight that litigation there? So it is actually meant to ensure that the criminal justice system is complainant-centric rather than accused-centric. For the police to go and do the investigation, there is merely just an additional expense. Ultimately, the state has to bear that. If the police has to go to Bombay, I mean, what difference does it make if the Bombay police does this investigation or Patna police does? The only difference is that the Patna police is not residing there. So if they have to go and do that investigation, they'll have to go, especially for that, probably stay somewhere in guest house or whatever they are entitled to in law, and while living there, do the investigation. So that's the only inconvenience, if you ask me. Otherwise, it's the same police, whether it be this police or that police. I mean, it's not that Mumbai police has anything additional with them to investigate this matter, which the Patna police does not have. So there is nothing of that kind in a criminal investigation. So that is why we realized that Patna is the right place for the FIR to be registered, and it was rightly registered. It is only when the SP was quarantined that we agreed for, because the CM had said all the parties were demanding that this matter should be referred to the CBI. And the CM had made the statement that if the father wants then only we'll refer it to the CBI. So when we realize that Patna police is being, there is impediment in doing the investigation, and Mumbai police is not cooperating, it is at that stage only that we decided that we'll go to the CBI.
Right, sir. So therefore, the short uptake is that you never registered a zero FIR. It was a FIR which was registered at Patna, and therefore the Patna police only had to investigate the FIR. So
Absolutely.
that, I think that clears away a lot of doubts, because I think it was argued also by Mr. Manu Singhvi that a zero FIR should have been registered and then transferred.
Yeah.
I think the difference has been very well explained by you, that it is the complainant who chooses, and also that the complainant will state that if there is a difficulty, only then a zero FIR is to be registered. So now, from what you said, a part of the
and this is exactly what the Supreme Court has held in
Yes.
its judgment.
Yes,
What I have just explained is what was my view, and fortunately for me, that is exactly how the Supreme Court has dealt with this in this case, and very categorically held that Patna police had the right to investigate also.
Yes, sir. Because that one line which I was going to read, Supreme Court says that inquiry conducted under 174. No, I'm sorry. That at the stage of investigation, Patna police is not required to transfer the case to Bombay police. I think court has. Sir, second, coming to what you said and what the court has held. The court has held that the Bombay police at a later date may register an FIR on the same issue. Now, sir, considering TT Anthony and considering that there cannot be more than one FIR on the same issue, what impact do you think this has for the future? Because herein the court has not once but twice held that the Mumbai police may still register an FIR on the same issue. Also, sir, keeping in mind that the FIR registered by Patna police does include 306 and is not limited to only misappropriation or cheating. So therefore, what impact do you think this has considering TT Anthony and Article?
Well, two things on this.
Yes, sir.
Firstly, the aspect of whether another FIR can be registered in Mumbai or not was not argued. So nobody argued that, and unfortunately, if that had been argued, we would have shown TT Anthony. But since it was not argued, we did not show. So the honorable judge has, because he felt that there is a Mumbai police inquiry going on, and if they want to convert this into an FIR, what should happen? So he probably was thinking it from that holistic perspective, without probably appreciating that there is already a TT Anthony. But probably what he may have in mind is that supposing there is some other death, which is also linked to Sushant Singh Rajput. For instance, Disha Salian.
Sir.
Today nobody is linking. I mean, officially nobody is linking. Media is linking, but none of the players are linking Disha Salian with this death. So supposing tomorrow Disha Salian FIR is registered, and in that FIR there is some reference to Sushant Singh Rajput's death as well.
Mm-hmm.
If that happens, then that FIR will also get transferred here. So probably he had that in mind. But what happens when a judge writes something in a judgment which was not argued, then these problems do come up. Because we had also not argued this because we knew that there can't be a second FIR. And
Right,
there was no question of, because of TT Anthony. So this was not argued. Nobody had, suggested that Mumbai can register a separate FIR. So probably what he meant was that if there is another FIR which is having some link to Sushant Singh Rajput, then that FIR also can be, will have to be investigated by the CBI. But probably if TT Anthony had been shown to him, probably he may not have made this reference if he meant the other FIR, if he meant the Sushant Singh Rajput FIR.
Some clarification there could have been, I think, could have avoided the.
Firstly, and secondly, even if you look at TT Anthony doesn't say that a second FIR cannot be registered. It says second FIR will have to be quashed. So
Yes.
supposing if an FIR has been registered, then this will suffer the quashing, or it will merge into this FIR. So something like that could have happened as well. So probably to obviate all that legal, confusions, the honorable judge felt that why keep any ambiguity, because when the judgment was delivered, the Council for the State of Maharashtra said that please give us the liberty to challenge the reference by the Patna Bihar government to the CBI, because they said that according to us, if this FIR was not correctly registered, then because nobody had read the judgment, then it had just been announced. So the judge very clearly said that no, I'm not giving that liberty because I've already used 142 as well to get the FIR get the FIR investigated by the CBI. So why should I, if I give that opportunity? So he basically wanted to give a quietus to the jurisdiction issue.
Yes.
And ensure that the investigation starts in full earnest, rather than bogged down in any further, litigation this issue.
Right, sir. Right. I think that could be an interpretation that can be given to the judgment to read it in line with P.T. Antony. Sir, another thing is that from reading of the judgment, the case was already transferred to the CBI. The petition by Riya Chakrabarti was for transfer from Patna to Bombay, and then thereafter, in her pleading, she conceded that she is okay with the transfer to the CBI also. So when the petition was heard, the case was already transferred, and eventually all that the court has done, it has said that in future, if there is another FIR, the same will also be investigated by the CBI. So in all your years of practice, do you think this enabling judgment, wherein based on a future contingency, the court has passed a verdict saying that this to happen in future. Do you think this is the first, or are there instances of such action being taken in a transfer petition earlier also by the court?
Well, transfer petition may not be, but transfer petition is merely the exercise of jurisdiction by the Supreme Court. But otherwise, Supreme Court has done in so many matters that any other FIR to be registered or any other complaint to be made or any other proceeding to be started will all go to a particular court. That has been done in several cases. So it's not something new. It's not as if something has been done because we referred, I knew this problem will come, and I anticipated Dr. Singhvi to argue that under 406 you can't exercise 142. So I had shown him a judgment on that as well, that in 406 you can exercise 142. And 406 before was by a division bench and now by a single judge will not make a difference on the exercise of the jurisdiction. Ultimately, the Supreme Court exercises jurisdiction either in single judges or 2 judges or 5 judges, depending on the nature of the matter before it. So that really does not change the nature of the exercise of the jurisdiction. The jurisdiction remains the Supreme Court jurisdiction. So if 142, if you read 142 doesn't say in exercise of jurisdiction in a division bench or more, or in a 5 constitution bench or more. It just says exercise of jurisdiction. So that is why 406, 142 can be exercised. 142 is the inherent power of the Supreme Court that can be exercised, and the judge has rightly held. But one aspect which we had argued, which if he had probably appreciated that, because there is no mention in the judgment, then probably this second FIR issue would not have arisen.
Yes.
In a case that I recently lost in Kamal Tanuj, IAS officer from Bihar, where consent had not been given by the state for there was an exception carved out in the consent given by the state for registering cases by the CBI. And the exception was that if any officer of the state is involved in any offense, then without the permission, specific permission of the state, further permission of the state, this consent is not valid. General consent is not valid. So the Supreme Court in that case ruled that the FIR was registered in Delhi, and since part of the cause of action arose in Delhi, so although there everything had happened in Patna, nothing had happened in Delhi. So it says since part of the cause of action had arisen in Delhi, so the consent in Delhi will inure to the benefit of the CBI to even investigate in Patna. So that was also, I had shown that judgment and I put it in my written submission also. If he had noticed that, then probably he would have realized that the Patna consent or the Bihar consent will be valid in Maharashtra as well. You don't need a separate consent for every state. Once a FIR is validly transferred to the CBI, by a state which had given consent to the CBI,
Yes.
then the jurisdiction of the CBI to investigate the matter in the entire country, even in states which have not given consent, is
Yes.
unfettered.
But
And
sir, I
to the-
think he went from the fact that the Bombay police will register another FIR, and then
I
he
know. So
on
the
that.
second FIR, if the PT Anthony, no, also probably what was troubling his mind that there is no consent by the state of Maharashtra. There is a reference in the judgment you will see
Yes, yes,
that there
yes.
is no consent. Maharashtra also can give consent for CBI. So that consent was not necessary because consent had already been given by the Bihar government, and Bihar government had already under that consent transferred the matter to the CBI. So Maharashtra consent separately was not required. So
Right.
probably he wanted to obviate that. He could have done it this way through the Kawal Tanuj route, or he did it the other way by the. But there he fell into the trap of TT Anthony. Here he could have done it through the Kawal Tanuj route. So that is judgments that are written by the judges. Their vision is of course much larger. So probably they have something more in mind, and
Yes.
probably he didn't want any ambiguity at all to remain. So that is
Later
why.
on, no further issues to prop up. So I think
Absolutely.
looking at that, sir, I think you already answered my question, but I was coming to that. Though the court has held that 406 is not applicable when the matter is of investigation only and not a case or appeal, he has dealt with whether a single judge can exercise the powers under 142 very briefly by saying that since it is the roster assigned to him, therefore he has the power. But I think you have already answered that, saying that it is not necessary that it has to be a division bench or a single judge.
No, on 406 also there is something very interesting.
Yes.
On 406, whether an investigation can be transferred or not, was a Krishna Iyer judgment of which we had cited,
Yes.
which had said that an investigation can't be transferred. Although a short judgment, but very, very clear on this part that it is only when the matter goes to court,
Yes.
and merely because there is a remand order or there is a application for remand, that will not be a matter to court. So, for instance, in our case, the moment FIR is registered, it is sent to the court. So, in that sense, the court is involved, but
Yes.
nothing is going in the court.
Yes.
So, Krishna Iyer had held that investigation can't be transferred because if you read 406, 406 talks of a court, either
Yes.
High Court or court subordinate to High Court.
Yes.
So Krishna Iyer said that at the investigation stage, this can't be transferred.
Yes.
But they relied upon two judgments where investigation had been transferred.
Mhm.
So we had pointed out that you read those judgments, there is no discussion whether this can be done. It has merely been transferred, but no discussion. And he rightly notices that in the Krishna Iyer judgment, there is a discussion that it can't be done, whereas the judgment is relied upon by them, there is no discussion that it can be done, but nevertheless transfer has taken place. So there, probably it was an exercise of 142 only, not read with 406, and that transfer must have taken place, or maybe nobody argued there, so that is why that transfer took place.
Yes, I think he's quoted from Justice Krishna Iyer's judgment and held that.
The one that we relied upon.
Yes, and held that. Right, sir. I think, sir, these are some of the major issues which were out there in the open. There is a couple of questions from the audience. I'd like to put you just one or two. Since
Why not?
Yes.
Why not?
So first is, do you think such media coverage / media trial may affect the case as far as law is concerned?
Well, this is unfortunately true for every high-profile case. Every high-profile case ends up in media trial, and every high-profile case definitely has some impact on the judge. It could be either way. So, but unfortunately, in our country and in most of the democracies in the world, the freedom of speech and expression and the freedom of the press has always been held to be a very paramount right and very, very well protected right. And in fact, the US Supreme Court has said that if you have to err, you have to err towards the freedom of speech and expression rather than, if there is a balancing to be done. So in that, if you see in that balancing, probably in such cases where the people want to know what has happened, the media ends up doing a trial. But I'll tell you how in this case it could have impact both ways. In this case, the way these channels are, going completely berserk, and some of them bringing in evidences and, examining Darwan and that locksmith and etc. on the channel before the trial has started.
Yes.
Now, what happens? You are exposing these witnesses to being influenced and to being even harmed. That's not something good for any criminal justice system.
Absolutely.
The other way also, this could also harm the accused, because if there is too much of media pressure and the judge is also persuaded to take a call because of the media pressure, because the media has already convicted somebody, that risk is always there in a media trial. But unfortunately, we have to live with it. There is no way we can, unless I had suggested some time back to bring in a law that, I have a very strong view on legislative control on terrorism. I had given a lecture in Parliament long time back.
Yeah.
That you should bar media from reporting who was the perpetrator of the offense and what was the objective.
Mm-hmm.
And in that, I had suggested a legislation also. And in that, one of the suggestion was that anybody in conflict with crime, there should be a bar of reporting. So the purpose was twofold. Firstly, if a person who's conflict with crime and he gets acquitted, then this media publicity he uses to become a member of parliament or a MLA, because he gets that visibility. If you look at it from an innocent person also,
Mm-hmm.
this media trial, completely kills his social life. So what defamation happens to. So either which way, this exposing a accused to the media is not a good thing for the. So it will not be. So that way the trial also will get quite an extent. Media will get controlled in that if that legislation were to be brought in. But unfortunately, nobody thought of this. Although this was a lecture given to international delegates, and they were very happy. They all said, "Why aren't we doing this?" Because ultimately, what does the terrorist, ultimately get? He doesn't want to destroy an institution. He wants to, supposing there is a bombing of the parliament, he doesn't want the parliament to be harmed. He just wants a big dhamaka, so that bigger publicity. And then the organization's purpose is, spread worldwide. So if you take away that incentive, probably they will resort to peaceful means. So it's in that discussion that this also issue comes up.
No, sir. I think that's a very very good point, because while handling the Mr. Peter Mukherjee's case in that Sheena Bora, we faced a lot of setbacks, and it was only due to it was prime time media story, even the smallest of things. So I think it definitely somewhere like you suggested, a law would go a long way in helping resolve these issues. So one more question which is there is that you think the delay in the investigation being transferred to CBI will affect the overall investigation and final outcome?
It may affect very badly. And if you ask me, the contemporaneous evidence, if there is something which has gone off from the house, if whatever was there at the house has not been, sort of confiscated or seized, if the postmortem has not been done correctly. So, for instance, the servant said that he had juice in the morning.
Mm-hmm.
Pineapple, anarka juice and nariyal pani. Now, if he committed suicide in an hour, then it should all have been there in his stomach. And probably the servants were introducing the juice because he was killed earlier. They wanted to show that he was awake in the morning, because nobody in the family had talked to him. So a poor postmortem report can really damage a case of this kind. And I don't see any way this postmortem can be improved, because the body is not there. It has all gone. What you've not tested, you've not tested.
Yes.
The hanging takes place, then there is an elongation of the neck. Asphyxia is one part. Asphyxia you can happen even if you put a pillow on somebody's head, and that also will result in asphyxia. But hanging has some additional features where your neck gets elongated, then eyes pop out, and you have some frothing from the face, etc. Nothing of that sort is there. Then there are some other injuries on the body which is not noticed. Now, all that could have been, properly done if the investigation had been done properly. So the police could have ensured that all these are taken care of at the time of postmortem. So police also was probably mixed up, or it was a pure inefficiency on their part, or the postmortem people were also, because even from small hospitals, we keep seeing postmortem reports in Supreme Court. I've never seen such a casual postmortem report being prepared like the one prepared in this case. So all that will be difficult to,
I believe a team of 5 doctors conducted the.
I know, but this is the level of the 5 doctors. If you don't, time of death is not given. Postmortem time of death is not given. Can you imagine time of death not being given in the postmortem? So these are some very, very big blunders, I would say.
Mm-hmm.
And these are questions which the police should have, supposing, I would say this is something which is normal in a postmortem report. But
Right.
the police should have, in any case, told the team that please ensure that these things come. And if they didn't come before the body is, sent for the for cremation, they should have insisted that where are all these, unless you give this, we will not permit the body to be cremated.
Yes, absolutely.
So these things are permanent damage to the investigation. But let's see, there is a lot of electronic trail in these days, which gives which traditional investigation did not have, as we know it in the good old days. So electronic trail can show a lot of things, which I'm sure a very competent team of the CBI, which I'm told is a very competent team, will be able to pull out.
Let's hope so. I think, sir, I think we have taken a lot of your time, but thank you very much because just from reading the judgment, the insights that you have given were not possible. And frankly, even I was quite confused as to how, in view of TT Anthony, still the court has passed the judgment. But that issue, sir, and also the fact of 0 FIR and Patna Police, I think it was very well explained to you. I'm sure all the students are brighter now. Thank you for your time and all the best for the future in this case.
Thank you.
Thank you so much for joining, sir. Thanks a lot.
Thank you. So how many people joined today? Any idea?
So we have approximately 600 live viewers right now on different platforms. We are being streamed live simultaneously on different social
Very nice.
platforms.
Very nice.
So,
that's very heartening.
thanks a lot, sir. Thank you for all your time.
Okay. Bye.
Thanks.
Thank you, sir.